Please be seated. Thank you. Before the trial begins, ladies and gentlemen, there are certain instructions you should have to better understand your functions as jurors and how you should conduct yourselves throughout the trial. Your duty is to decide this case based only on the evidence presented at trial and the law given to you by the court. Anything you may have seen or heard or read outside of the courtroom is not evidence. Do not let any personal feelings affect your consideration of the evidence. Do not begin your deliberations and discussions of the case until all of the evidence is presented and I have instructed you on the law. Do not discuss this case among yourselves or with anyone else until you begin your final deliberations in the jury room. We are going to stop or recess from time to time during this trial. You may also be excused from the courtroom when it is necessary for me to hear legal arguments from the attorneys. If you come in contact with the lawyers, the parties, or witnesses, do not speak with them. For their part, they will not contact or speak with you while you serve as a juror on this case. Do not listen to any conversations about this case. Do not research any information that you personally think might be helpful to you in understanding the issues that will be presented. Do not investigate this case on your own or visit the scene. Do not read any newspaper reports or listen to any news reports on the radio or television about this trial. Do not conduct any experiments or try to reproduce any of the factual scenarios. Do not consult dictionaries, computers, websites, or any other reference materials for additional information. Do not seek information regarding the public records of any party or witness in this case. The reason being, ladies and gentlemen, is that any information you obtain outside of the courtroom could be misleading, inaccurate, or incomplete. Relying on that information would then be unfair because the parties would not have the opportunity to refute, explain, or to correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this panel. Do not use a computer, a cell phone, or any other electronic device with communication capabilities to share any information about this case. For example, do not communicate by blog, email, text message, Twitter, Facebook, or in any other way on or off a computer about this trial. Do not watch news coverage or any live streaming coverage of the trial proceedings. Do not access any social media sites that may be covering this trial. Do not permit anyone to communicate with you about this trial, and if anyone does so despite your telling them not to, you must report that to me. I appreciate that it will be tempting when you go home this evening or any evening during the trial to discuss this case with another member of your household. Please do not permit that to happen. This case must be decided by you, the jurors, based on the evidence that will be presented in this courtroom. People not serving on this jury have not heard the evidence, and it would be improper for them to try to influence your deliberations and decisions in this case. After the trial is completed and you've been discharged, you are then free to communicate with anyone about your experience in any manner. These rules, while they appear onerous, are simply intended to ensure that jurors remain impartial throughout the trial. And if any of you has reason to believe that another juror has violated these rules, again, you must report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and taxpayers of St. Croix County. As a result, ladies and gentlemen, you are to decide this case solely on the evidence that will be offered and received during this trial. You may ask yourselves, what is evidence? Evidence is defined as follows. First, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who calls a witness to testify. Second, exhibits the court receives, whether or not those exhibits go with you to the jury room ultimately. Third, any facts to which the lawyers agree or stipulate, or which I direct you to find. As a result, again, anything you may have seen or heard or read outside of this courtroom is not evidence and must not be considered by you. Attorneys for each side, ladies and gentlemen, have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusion from the facts that objections may be made during this trial. By allowing testimony or other evidence to be received over the objection of an attorney, the court is not indicating any opinion about the evidence. You jurors are the sole judges of the credibility of the witnesses and the weight of the evidence. You are not required to, but you may take notes throughout the trial, except during the opening statements and closing arguments. The court will provide you with those materials when the first witness is called. In taking notes, however, be careful that it does not distract you from carefully listening to and observing the witnesses. You may rely on your notes during your deliberations to refresh your memory regarding the evidence. Otherwise, please keep them confidential. And after the trial is completed, those notes will be collected by the bailiff and destroyed. You will not have a copy of the written transcript of the trial testimony available for use during your deliberations. As a result, you should pay careful attention to all of the testimony because you must rely primarily on your memory of the evidence and the testimony that will be introduced during the trial. During the course of this trial, the attorneys may refer to, or use police reports with various witnesses. Normally, these reports will not be provided to you. And if you are not provided with the police report, again, you should use your collective memory regarding any reference that may have been made to those reports. It is the duty of this jury, in fact, any jury, to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You, again, are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of this trial. The witness's conduct, their appearance, and their demeanor on the witness stand. The clearness or lack of clearness of the witness's recollections. The opportunity the witness had for observing and for knowing the matters the witness has testified about. The reasonableness of the witness's testimony. The apparent intelligence of the witness. Bias or prejudice of a witness, if any, is shown. Possible motives for falsifying testimony. And all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There is no magic way, ladies and gentlemen, for you to evaluate testimony. Instead, you should use your common sense and your experience. In everyday life, each of you determines for yourselves the reliability of things people say to you. You should do the same thing in this courtroom. When asked to reach your verdict, examine the evidence with care and caution. You will be instructed to act with judgment, with reason, and with prudence. Persons alleged to have committed crimes are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the person is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state of Wisconsin. Before you can return a verdict of guilt, the evidence must satisfy you beyond a reasonable doubt that Kayle Fleischauer is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with Mr. Fleischauer's innocence, you should do so and return a verdict of not guilty. The term reasonable doubt, ladies and gentlemen, means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of making a decision. While it is your duty to give Kayle Fleischauer the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth and give Mr. Fleischauer the benefit of a reasonable doubt if it arises in your minds after you have carefully considered all of the evidence in this case. At this time, the lawyers will make their opening statements. The purpose of the opening statement is to give the lawyers an opportunity to tell you what they expect the evidence will show so that you will better understand the evidence as it is introduced during the trial. In other words, an outline. I must caution you again, however, that the opening statements are not evidence. Likewise, anything that I've said in introducing this case, in these instructions, is not evidence. You will begin your consideration of the evidence when the first witness is sworn and takes the stand. With that said, Mr. Kaiser will address you first, followed by Mr. Gray.